Welcome back to the Law Show. Bob Kerrigan with you and talking about various subjects. But I probably failed to say in the first segment that we will respond to your text messages if you will send them to us while the program is airing. It's 850-444-4444. That's text messaging to us. And you can also send us an email, though we don't get as many emails these days as we used to. We get text messages regularly. It's lawshow@kerrigan.com, KERRIGAN.com. Kerrigan, Estus, Rankin, McLeod, Thompson is a regional law firm specializing in injury and death claims. We've been here for many, many years. Started the firm with personal injury litigation in 1973. And have the same partners that we've always had in the firm: Kerrigan, Estus, Rankin, McLeod, and Thompson. So we've been around a long time in North Florida. We have offices across the Panhandle. We're able to consult with people on these serious injury and death claims. We can also affiliate with lawyers outside of the state of Florida. We handle cases throughout Florida without any special admission privileges from the courts. And we can obtain that permission in another state for a special right for us to practice in that state in conjunction with another lawyer or law firm located in that state. And that's to the advantage of everybody involved, because you want local lawyers that know what's going on in their court system. And those are the rules of most states, that you have to be licensed in that state or admitted for special privileges in that state for the case that you're handling. And so that's the way we generally do that. And we can consult on cases outside the United States. That's rather unusual, but we have had them, and we have access to people in other countries that can help depending on where this event occurred. And that does come into play because of our military families, okay? Because we're a big military community in North Florida, as everybody knows. I said in an earlier segment, if you just joined us, that we are going to have on the Sunday after Thanksgiving a special guest, Danielle Kunkel-Roberts. This is her book right here, which is pretty interesting, on a bestseller book. It's called 10 Costly Medicare Mistakes. And so we are very anxious to talk with her. And there's some subtleties in this book that I did not realize about Medicare that I think will be beneficial to people, especially if you're thinking about going on Medicare or if you're eligible to go on Medicare. In the first segment, we talked about this disparity in health care for African American women and Hispanic women compared to white women in terms of pregnancies and fetal deaths. It's just a very serious problem in the United States. And the United States, as I mentioned in the first 15 minutes, we have the worst record of any industrialized country on deaths from during pregnancy. It's just alarming to me, because we have just such marvelous health care in so many ways, and really outstanding physicians. I mean, you can criticize various aspects of the healthcare community and healthcare services, but we do have wonderful doctors. And I always said, I want the smartest people in my class to be a doctor, not a lawyer. It's a lot better, because when you go in there, you want the smartest person you can get to be taking care of you. So my brother had a PhD in anatomy and was a professor in a medical school and worked with us for years in our medical malpractice cases. So we've been involved with this kind of work for a long time, and we try to find the best people we can to help us with our cases. And with our medical malpractice cases, we consult other physicians to tell us what's going on here. Physicians that do that exact kind of procedure that's involved in the medical malpractice claim. I will say this about medical malpractice, though, because there's a great misunderstanding about it. The vast, vast majority of people who call us about medical malpractice, we cannot accept their case. And the reason is that you must have in Florida a very, very serious long-term injury or a death before lawyers who specialize in this kind of work will undertake the case. And the reason is it's very expensive to do it. The cases are very difficult, and many people have complaints about what happened to them, but they had a bad outcome. It wasn't malpractice, it was just a bad outcome. And you can have a bad outcome in medical care. So it's unfair to the physicians and the hospitals to assume that because you had a bad outcome that somebody made a mistake. But you can have a mistake that causes a bad outcome. And that's what a medical malpractice case is all about. Well, some interesting information, by the way, for people who say we don't need the government and we got too much government looking out for us. I suppose there's some arguments for that. But in terms of consumer product safety, we need a vigorous review, because if you don't have a government commission of some kind reviewing products, you can have very unscrupulous people build a product, put it in the marketplace, make a lot of money, and could care less if it's causing death or injury, and especially protective of children. So the Consumer Product Safety Commission is really, really important, and as is the FDA in terms of protecting our health and our safety. And there's nobody else that can do it. If you think about it, who's going to undertake that responsibility to protect the public from dangerous products or dangerous drugs or drugs that have not been properly vetted? If we didn't have that, can you imagine? I mean, it wouldn't be a whole lot different than the stuff that goes on in China and in Russia, where products get out there, they're sold, and no really regulatory control over them. We have that in this country, and in Europe as well, but we have that in this country. So I'm very proud of that part of it, and I think it's a critical function of government to provide information to us, not take care of us, not to be our parent in place of our parent, or to be, guiding us in everything we do in our life, but to protect us from things we can't protect ourselves from, which are dangerous drugs and dangerous products, because we don't know about them until somebody gets badly hurt. An arm gets cut off, people take medication and have an adverse reaction that they destroy their kidney or whatever it might be. So the point is, Consumer Product Safety Commission, the FDA, these are parts of government that are there to protect us. And so I highly recommend going to their websites. For dangerous drugs that shouldn't be on the market, the FDA has a long list of drugs that have been taken off the market for one reason or another. And the Consumer Product Safety Commission has a long list, a very long list of products that have been recalled because they are dangerous to children. Everything from the way a baby bed's manufactured to a particular problem with an automobile or any other product. And so highly recommend that you go to those websites, the Consumer Product Safety Commission and the FDA. So let me just talk a little bit about some recommendations here that have just come out, and then I'll talk a little bit more at length about it. The FDA is recommending avoiding the use of NSAIDs in pregnancy at 20 weeks or later because they can result in low amniotic fluid. The FDA recommends avoiding the use of the NSAIDs in pregnancy at 20 weeks or later. The FDA warns about serious problems with high doses of the allergy medicine Benadryl, and the FDA cautions against use of, well, we all know this, hydroxychloroquine. We've all been through that story, but the FDA has said don't use it, for COVID. But let's go to this NSAIDs business and talk a little bit about that for pregnant women, because this is really important, because these are pervasive. These NSAIDs are pervasive in medicine. Again, the U.S. Food and Drug Administration is warning that use of nonsteroidal and anti-inflammatory drugs, NSAIDs, around 20 weeks or later in pregnancy may cause rare but serious kidney problems in an unborn baby. This can lead to low levels of amniotic fluid surrounding the baby and possible complication. NSAIDs are commonly used to relieve pain and reduce fevers. They include medicines such as aspirin, ibuprofen, naproxen, and others. After around 20 weeks of pregnancy, the unborn baby's kidneys produce most of the amniotic fluid, so kidney problems can lead to low levels of the fluid. Amniotic fluid provides a protective cushion and helps the unborn baby's lungs, digestive system, and muscles develop. Although this safety concern is well known among certain medical specialties, this is from the FDA, we wanted to communicate our recommendations more widely to educate other healthcare professionals and pregnant women. The issue affects all NSAIDs that are available by prescription and those that can be bought over the counter without a prescription. For prescription NSAIDs, we are requiring changes to the prescribing information to describe the risk of kidney problems in unborn babies. At around 30 weeks, NSAIDs can cause a problem that may result in heart issues in the unborn baby. If deemed necessary by healthcare professional, use of NSAIDs between 20 and 30 weeks of pregnancy should be limited to the lowest effective dose for the shortest duration. And NSAIDs include aspirin, ibuprofen, naproxen, and others. NSAIDs are used to treat medical conditions such as arthritis, menstrual cramps, headaches, colds, and the flu, so they're fairly common out there. Just be aware of that if you're pregnant and you are reaching 20 weeks. Be sure and consult with your obstetrician and don't take these products. Be especially careful of those products. All right, let's go to the grand jury. I'm going to cover this quickly. When we come back for the last segment of the show today, from quarter after 10 to 10:30, we're going to talk about class action lawsuits, and we're going to talk about mass torts. What's the difference in these two concepts, mass torts and class action suits? So there is also a Florida statewide grand jury that addresses problems across the state. They don't hear too much about them. They deal primarily with things that are going to be involved with more than one county, and sometimes they have that happens. The federal grand jury has between 16 and 23 members. They need the concurrence of 12 members required to return an indictment. They must issue before an individual can be tried for any felony offense arising under federal law. Federal grand juries lack the civil investigative power according to the Florida grand juries. Okay, so there's two differences. The federal grand juries can return indictments for any felony, and they are subject to the same general restrictions of privacy and protect the identity of the people testifying before the federal grand jury. That's it for this segment of the Law Show. I'll be back with one of the lawyers from Kerrigan, Estus, Rankin, McLeod after this message.